And keep in mind that, now that Kyle Rittenhouse has raised the legal defense of self-defense, he doesn't have to prove self-defense. The burden's on the prosecution to disprove self-defense, and not just by a little bit, but to disprove self-defense beyond any reasonable doubt.
I just want to ask you about the burden of proof, because my understanding, at least one other lawyer in Wisconsin said that at least some of the burden will be on Rittenhouse, since they're invoking the self-defense defense, and that they will have to. I mean, they can't decline to put on a case if they're invoking that defense.
Right. So how that works,
right?
I could explain that to you, is there's really two burdens of proof. One is what's called the burden of production. And this is the amount of evidence that has to be shown before you're allowed to argue self-defense in the first case. You don't have an absolute right to argue self-defense. If I just walked up behind somebody and shot him in the back of the head, where there was no way that could possibly have been self-defense, I'll be denied the privilege to raise the legal defense of self-defense in the first place, because I'll have failed to meet my burden on raising the defense. But the burden on raising the defense is basically more than zero evidence. It's a very, very low threshold. Rittenhouse has clearly met that threshold. There's no question but that Judge Schroeder's going to allow self-defense to be argued at trial. So their burden's been met. That's done. Once they've met...
Sorry to interrupt you, but will they have to enter that evidence at trial? And obviously they've been talking about this for over a year, but does it have to be done at the trial as well?
The video itself is sufficient to meet that burden of production on the legal defense of self-defense.
But they still have to enter that at trial. And in other words, they have
it doesn't have to be their evidence. The evidence can be from any source. So whichever side submits the video of the event as evidence, and either side could do that. Both sides are going to want to, I would presume. But however that video evidence is presented, the video evidence doesn't matter where it came from or who presented it as evidence. It's sufficient to meet that prima facie burden of production to raise the legal defense of self-defense for trial.
Got it.
So there's no vulnerability for the defense there. That's right. Non-existent. And once they've met their burden of production and they're privileged to argue self-defense in front of the jury, which they clearly are, there's no question that's going to happen, then the burden shifts to the state, and the state has the burden of persuading the finder of fact on the issue of self-defense, and they have to persuade the jury, the finder of fact, that they've disproven self-defense beyond any reasonable doubt. Otherwise, the jury's instructed they must acquit the defendant.
Will the judge actually use that? I mean, again, you can't judge what a judge is going to do, but I mean, is that pretty common that the judge would actually put it like that if they haven't met the prosecutors did not meet their burden, they have to acquit?
Yeah, I would expect. I mean, obviously, I don't have the jury instructions of all 50 states memorized, but I've certainly looked at the jury instructions for self-defense of all 50 states at one point or another, and that's the common phraseology.